In countless police procedurals and legal dramas, we've seen it play out. An arrest is made, and the suspect instantly demands, "You didn't read me my rights." The implication is often that without this immediate recital, the entire case is somehow invalid, paving the way for an easy dismissal. It's a compelling narrative, deeply ingrained in public consciousness, suggesting a clear path to freedom if the police forget these crucial words. But while Miranda warnings are a cornerstone of our legal system, the reality of their application and impact is far more intricate than what television suggests. This common misconception often leads to significant misunderstandings about legal processes. The Miranda warning is not merely a courtesy, it's a vital safeguard derived from the Fifth Amendment of the U.S. Constitution, which protects against self-incrimination. It ensures that individuals in police custody are aware of their right to remain silent and their right to an attorney. These rights are fundamental to a fair legal process, designed to prevent coercion during police interrogations. They serve as a critical check on state power, ensuring that any statements made by a suspect are truly voluntary. Understanding these core protections is the first step in demystifying the police never read me my rights dilemma. The Miranda warning's origin traces back to a pivotal 1966 Supreme Court case, Miranda v. Arizona. Ernesto Miranda was arrested for kidnapping and rape. During interrogation, he confessed without being informed of his rights. His conviction was overturned, leading the Supreme Court to rule that detained criminal suspects, prior to police questioning, must be informed of their constitutional right to an attorney and against self-incrimination. This decision forever changed police procedure, establishing a clear standard for protecting individuals during custodial interrogations. It recognized the inherent pressures of police custody and mandated warnings as a necessary counterbalance. Crucially, Miranda warnings are only required under specific circumstances, when a person is both in custody and subjected to interrogation. Being in custody means a person's freedom of movement has been deprived to a degree associated with a formal arrest. Interrogation refers to explicit questioning by law enforcement or any words or actions that officers should know are reasonably likely to elicit an incriminating response. If either of these conditions is not met, officers are not obligated to issue the warning. This dual requirement is often misunderstood, leading many to believe Miranda applies universally to all police encounters. There are many common police interactions where Miranda warnings are not legally required. During a routine traffic stop, for instance, a driver is usually not considered in custody, so questions about license and registration don't require Miranda. Similarly, if you volunteer information to an officer without being questioned, or if you're merely a witness providing a statement, Miranda isn't triggered. Even general, on-the-scene questioning at a crime scene, intended to determine what happened, does not typically require the warning. These scenarios highlight the critical distinction between investigative questioning and custodial interrogation. So, what happens if the police do violate Miranda by failing to read the warnings when they should have? The primary consequence is the exclusionary rule, which dictates that any incriminating statements made by the suspect during that unwarned, custodial interrogation cannot be used against them in court. This is a powerful remedy designed to deter police misconduct. The confession or statement is suppressed, meaning it's rendered inadmissible. However, it's important to understand that this rule applies specifically to statements. Physical evidence obtained as a result of an unwarned statement generally can still be admitted. This brings us to the core question: does a Miranda violation lead to an automatic dismissal of the case? The answer is almost always no. While suppressed statements can significantly weaken the prosecution's case, particularly if the confession was central to their evidence, it doesn't automatically mean the charges disappear. The prosecution can still proceed with other independent evidence, such as eyewitness testimony, forensic evidence, or evidence obtained before or after the Miranda violation. If there's sufficient evidence apart from the excluded statement, the case will continue, and a conviction can still be secured. The application of Miranda also has nuances and exceptions. For instance, there's the public safety exception, where officers can question a suspect without Miranda warnings if there's an immediate threat to public safety. Imagine a scenario where an officer asks where a discarded weapon is after an arrest. The answers can be admitted even if Miranda wasn't read. Additionally, physical evidence derived from an unworn statement, unlike the statement itself, is generally not suppressed. These exceptions underscore the complex and practical considerations that judges and law enforcement must navigate in real-world situations. Given these complexities, what should you do if you find yourself being questioned by police? The most prudent course of action is always to clearly and unequivocally invoke your right to remain silent and your right to an attorney. Simply saying "I want a lawyer" or "I am remaining silent" can protect you. Do not assume silence is enough, you must assert these rights. Once you invoke your rights, police must cease questioning. While Miranda can be a powerful shield, it requires your active participation. Seek legal counsel immediately if you are arrested or subjected to police questioning. In conclusion, the Miranda warning is a crucial legal safeguard, ensuring that individuals are not compelled to incriminate themselves during custodial interrogations. However, the popular notion that a missed Miranda warning automatically dismisses a case is largely a myth. It is a shield that prevents the use of unworn statements, but it rarely serves as a sword to unilaterally end a prosecution. The legal system is built on layers of evidence and procedure. Understanding these nuances empowers us to protect our rights more effectively and appreciate the intricate balance between law enforcement's duties and an individual's constitutional protections in a truly informed manner.